Hello. In this video from Justia webinar, Requests and Forms as Modern as the Evidence You Seek, Craig Ball, trial lawyer and certified computer forensic examiner, talks about the nature and variety of emerging electronic evidence in litigation and guides us on how to craft a practical and proportional production protocol that serves all parties' interests. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Hello, everybody, and welcome. We're so glad to have you with us for another Justia webinar presented by Justia Connect. If you haven't met me yet, my name is Marina Wilson. I'm a member of Justia's marketing team and a lawyer like all of you, and I'm going to give you a quick introduction. So I won't keep you here. I'm going to turn things over to my colleague, Nina. She's going to introduce today's speaker and help us kick off the presentation.
Thank you, Marina, for welcoming all of us here today. My name is Nina, and I'll be the moderator for this webinar. I wanted to start out by giving a bit of background on our speaker, Craig Ball. Craig Ball hails from Texas, works in Austin, and happily calls the Big Easy home. A graduate of Rice University and the University of Texas School of Law, Craig is a trial lawyer and certified computer forensic examiner. Craig is an adjunct professor at the University of Texas School of Law and Tulane Law School, teaching electronic evidence and digital discovery. He is also a founder of the Georgetown University Law Center e-Discovery Training Academy and serves on the Academy's faculty. Craig is an expert in digital forensics, emerging technologies, visual persuasion, electronic discovery, and trial tactics, limiting his practice to service as a court-appointed special master in electronically stored information. The webinar presentation will be approximately 1 hour, and Craig will be taking audience questions after the presentation is complete. If you have any questions for Craig, please feel free to click that Q&A button at the control panel at the bottom of your screen and submit your questions. Without further ado, here is Craig to discuss requests and forms as modern as the evidence you seek.
Thank you, Nina, and thank you, Marina. Thank you very much, Tim and Vasu and my other friends at Justia for allowing me this time to talk about a topic that's very dear to my heart, and that is enhancing the quality of litigation and making it more affordable by seeking better and enhanced forms of evidence in production. So let me share a little story. Here in New Orleans, we pretty much start everything with a cocktail and a story. And this goes back a week ago. Last week, my buddy Tom O'Connor, Tom being the Harley-riding, curmudgeonly Santa Claus of the legal tech community. So Tom invited me to a meeting of the e-Discovery Committee of the New Orleans Bar. Now, I'm licensed in Texas, but Tom promised lunch, so I said, sure, why not? New Orleans is not what you'd call a cutting-edge community. We still light our homes with natural gas, leery of the fad that Tom Edison boy put forward called electricity. So I was not terribly surprised when only 7 people showed up at the meeting of the e-Discovery Committee. One who came was a 50-ish solo practitioner, and he groused that he'd asked for native production of email, but the other side wouldn't produce it. So I asked him, what native forms did you seek? And he looked at me like I was suffering from timely onset Alzheimer's, and he raised his voice slightly and he said, native? I asked for native. Well, he had no clue what I was asking. He didn't know what native form or forms he wanted. He just knew he wasn't getting it. And he was incensed that when he moved to compel native production, the judge expected him to explain why he needed a form other than that which the other side had already supplied. And he kind of lost his temper and said, somebody needs to educate the judges. Now, it took all my restraint not to say why, so the judges can understand arguments you don't know how to make. But I was a little less snarky than that, thankfully, uncharacteristically, because look, when it comes to seeking metadata and preferred forms of production, if we can't articulate the need for it, why do we expect to get it? Somebody really does need to educate those judges. You know who I think needs to do it? I think it needs to be us. I think it needs to be the lawyers. It's our job It's the lawyer's job to educate the judges. I don't mean to dump on the guy who came to the meeting. He showed up where 40 other committee members blew it off. But it was a reminder to me, after 20 plus years trying to turn this battleship, how little progress has been made when it comes to lawyer competence on the topic of forms of production. So when I teach e-discovery, I use the electronic discovery reference model, the EDRM schematic, to equate my students with the stages of e-discovery and some of the language of ESI, electronically stored information. Now, many of you watching may have seen the EDRM diagram before in one form or another. It's a brilliant and durable diagram that's withstood the test of time. But it doesn't reflect a certain reality that discovery doesn't end with production to our opponents. For requesting parties, someone I often identify with much more than producing parties, the process is just beginning when the data arrives. Because there's really a second EDRM phase, and it's something that we hardly ever think about, and it's this. When we receive the production, there's a whole additional step of ingestion and processing and review and analysis and ultimately presentation in proceedings. And so in order to deal with that, I want to focus today on just one part, one stage, and I'll concentrate on the production state, in particular, forms of production, and how some pretty simple tweaks in how you approach forms can make a big difference in what you see and, importantly, what you spend in discovery. A good place to start is with the language of the rules themselves. And here I'm going to go back to the Federal Rules of Civil Procedure as they were amended, first in 2006 for electronic discovery, and again in 2015, in an attempt to cope with the growing dominance of electronic evidence. So the language in particular I want to talk about today is Rule 34B1. And 34B1, let me tell you a little story. I'll call it Mr. Ball Goes to Washington. 18 or so years ago, when the first set of e-discovery rules amendment were under consideration in public hearing phase, I appeared before the Rules Committee in DC, and I pleaded with them to change the proposed language that would allow a requesting party to specify the form for production. And I instead asked them to change the language to refer to the form or forms of production. Because as I explained to the committee, there is no single form that works for every type of ESI we would be expected to produce in discovery. Lawyers are obliged to fit the form to the type of ESI. And so I'm very grateful that long time ago that the committee listened and they made the change I thought. And so the language of 34B1 gives a very great gift to the requesting party that wasn't in the language of the rules beforehand. And that is, it allows the requesting party to specify the form or forms in which the ESI is to be produced. And the federal courts are not alone in this great capability, and that is your own California rules, CCP 2031.030, adopted identical language, allowing a party to specify the forms or forms in which each type of ESI is to be produced. So let's take a moment and consider our goals in construing the rules. The federal rules begin with Rule 1, and Rule 1 says that the rules should be construed in order to bring about a just, speedy, and inexpensive resolution of the case. And I always think it's very important, looking at this from the requesting party point of view, to never allow your opponent to forget that there's a all-important comment between just and speedy, because a lot of my opponents just want it speedy and inexpensive, and it's got to be just. And what does that mean as we approach forms of production? What makes it just, speedy, and inexpensive? Well, I'd suggest that as we approach the issue of just, forms that are just are forms that are utile, are forms that are searchable, and forms that are reasonably complete. And again, how much so? Not perfect, but reasonably so. And what does speedy mean in the context of forms of production? Well, for me, it's producing in forms that don't entail a lot of superfluous processing, but that allow us to process and extract the information in any tool and platform we prefer. And it's tending towards forms that are used in the ordinary course, that the forms I get in a level playing field of litigation should reasonably approximate the completeness and the utility and the searchability of the forms used by the producing party. And perhaps most importantly of all, in a world where proportionality is increasingly the watchword of electronic discovery, we have to ask, should it matter if the forms produced prompt an undue expense for one party versus another? Certainly, producing parties are quick to say that if a request prompts them to incur unreasonable expenses, that request is disproportionate and should not be allowed. But the other side of that proportionality coin needs to be, can a producing party dumb down or alter the form of production to visit significantly increased and undue expenses on the requesting party? So let me, before I even make the argument for it, for fear that something could happen, let me please give you the most important takeaway of this discussion today. And it is this: you've been given a great gift in Rule 34 and in the CCP counterpart. Always, always, always specify the form and forms of production. Never let that opportunity go by. Never punt. And so some of you may be thinking, come on, Craig, do the forms of production really matter? I mean, all I want to do is be able to read it. Isn't something like a printout going to be good enough? Well, let me switch gears and go to an entirely different context and reason by analogy. You know, I'm born in 1957, so I've seen a lot of changes, as many of us have, in entertainment over the course of those years. And one of those things is the aspect ratio wars that you may or may not be conscious of. You know, before 1953, movies were filmed in what's called a 4:3 ratio, a little wider than they are tall. And so when televisions were created, they were also roughly 4:3. And the movie studios were terrified that no one was going to go to the theaters anymore. Everyone would watch movies on TV, and that would be the end of theaters. And so what happened is the studios after 1953 started moving to widescreen formats, CinemaScope and Panavision and Cinerama, and a whole host of widescreen things that were the ability to try to draw people off their couches and back into cinema seats. And so what happened is, as you were trying to watch in modern times 4:3 formats, like the first few years of the Seinfeld show or The Simpsons, many, many years of those two shows were filmed in 4:3. And if you watch them on a newer, wider screen LED style TV, well, you had to have pillar boxing. You either had to have them stretched unnaturally, or you had to have some black boxes on either side so you would fit it to the wide screen. More familiarly, way back in the days of VHS tapes, is as you were trying to watch a widescreen movie, a Cinerama or Panavision movie on a standard television, they had to turn to something called letterboxing and put black boxes above and below. Well, in time, American TV viewers hated letterboxing. They felt like it was too small. And so broadcasters turned to something even more hateful called pan and scan. And some of you may never have heard of pan and scan. So a year ago, I went to Milan and I went to see the famous fresco of the Last Supper. And what you're seeing here is a picture I took, and it's huge. It's an entire wall inside a church. And you can see in the center bottom, there is a top of a doorway to give you a sense of the scale of this painting. And so it's widescreen in the sense that its aspect ratio is much wider than it is tall. And so if one were projecting that image size on televisions during the 1970s and 80s, what you would have gotten is pan and scan. Instead of seeing the whole image, the television folks would reduce the size to 4:3. And if somebody spoke off to the left side, they'd shift the pan over to that person, killing the entire right half. And then if somebody spoke off to the right, they might shift the focus over. And for many of us who grew up seeing great widescreen movies only on television, we didn't really understand just how much we were missing. And so in lieu of black bars, viewers lost half the visual information. And forms of ESI production are kind of like that, in that most of us don't really know what we've been missing. And so let's talk for a moment about what's missing. When we speak of electronically stored information, let's step back and say, what is that evidence? So what is the optimum unitization for electronically stored information in e-discovery? We don't stop to think about that often, if at all. I mean, is it documents? Is it pages? Is it lines? Now, if I were to say lines, many of you would go, that's crazy. And yet in California, when you get a deposition, every line is numbered and it's essential part of the reference mechanism. The division is by page and line, and we take that for granted in transcripts. But I propose that when we live in a world of electronically stored information, the optimum unitization is files. Think about it. Applications store information in files. We users use files. Lawyers and clients collect files. Vendors process files. We dedupe at the file level, and we review at the file level. And so when we think about what the evidence is, I'd argue that the evidence is the native file, not some other diminished form, but it's the native file. That's what the witness created and used. It's what we preserve. It's what we collect and index, and it's the optimum form because it holds the richest and most complete informational payload. Yet many producing parties keep producing ESI in TIFF plus formats. And so some of you, I hope, are saying, what do you mean TIFF plus formats? And so forgive me for those of you who are well familiar with it, and let me just lay a little more groundwork here. Imagine you have a case involving, say, allegations of domestic abuse, and you have the image, which is a color JPEG photo like this. Were it produced in electronic discovery today, the standard form by which it would be produced is called a tagged image file format, or TIFF image. It's a black and white monochromatic rendering of the evidence. One image per page, so a picture of each page, essentially an electronic printout. And the TIFF format does not contain searchable text. Think of it kind of like a black and white PDF with no searchable text and no native metadata coming from the originating photograph. Were the originating evidence, say, a color PDF produced as a TIFF image, you would see that it's generally a lower resolution. And if color matters as a way of achieving some level of intelligibility, that intelligibility is significantly diminished or eliminated altogether by virtue of turning it into TIFF. Now, generally speaking, it doesn't work too badly for your plain vanilla black and white printed document, or at least that's what we came to believe from years ago. And I should point out again that TIFF images are not text searchable, where native PDFs and other ESI and native formats are inherently electronically searchable. And some of you may be saying, well, no, that can't be right. That can't be right. But let's talk about it for a moment. We live in a world where most electronic discovery still takes the form of native productivity formats, things like Excel spreadsheets, word process documents, emails, and presentations. Now, when we get these things in their native formats, those formats are original, they are fully searchable, and they are complete. They are the actual electronic evidence. But when they fall into the abyss of electronic discovery today, the standard for too long has been a TIFF image conversion, taking a essentially black and white photograph of each page of many forms that aren't really paged at all. And what you end up with are these TIFF images that are not original, not searchable, and certainly not complete, because they've been stripped of their text and stripped of their metadata and stripped of the features that make electronic evidence so superior to old paper-based evidence. Now, because the law requires that searchability not be completely eliminated, the processes of producing in TIFF led to a so-called TIFF plus production. In order to meet the requirements of some crude level of searchability, what had to happen was a kit had to be created. You got the black and white non-searchable image of the page, and then you got another file or files that would contain some extracted text from that page. And then you had to somehow pair that arriving in so-called load files with each page image and try to make it all work. And so you needed e-discovery software. In the old days, it was tools now largely gone, like Concordance and Sanction and others. But today, we would be using other better known e-discovery products. The problem that we don't talk about, and I'm going to spend some time addressing here today, is that these TIFF files are also many times the size of their native counterparts. So they're not only less utile, complete, and functional, but they cost you significantly more to load and host and to export and use. Now, here's the rub. Parties don't use TIFFs. Your clients don't use TIFFs. Your opponents don't use TIFFs. Only lawyers use TIFFs. And that's kind of crazy. So let me take another historical perspective and talk a bit about how we got into this mess. And that requires that I give you a short history of TIFF production, bringing you back to the era when I became a young lawyer, the 1980s. Back when I became a young lawyer, we would still go to court carrying one of these red rope folders with file folder materials under our arms. You could really do that in that day. And then very quickly, in a paroxysm of new technologies, something funny happened. Suddenly we had word processing in almost all law offices, allowing us to generate a much larger volume of customized documents at a much quicker pace. And photocopiers became ubiquitous, allowing for more duplication, more distribution, and finally civil discovery began to be used more strategically to win cases. And so very quickly, going to court stopped looking like a young punk like me with a red rope folder under his arm walking to the courthouse, and going to court began to look something more like this. And being in court started to look more like this. And we started to be up to our ears in paper. And so we needed to bring technology to bear on this new paper deluge, and that brought about the advent of something we take for granted everywhere today, but didn't exist when I became a young lawyer, and that was electronic search of the information in our cases. And it was born of fairly new technologies like electronic scanners and optical character recognition that allowed us to take an inherently unsearchable document, like a paper document, put it on glass, scan it, and make it electronically searchable through OCR. And so the 20th century forward-looking Star Trek, Star Wars approach to discovery was the paper original would be scanned to a TIFF image, and then that would be subjected to optical character recognition. Well, you couldn't put the searchable text in a TIFF image, of course, so it had to go into an ancillary file called a load file to be loaded in a review platform. And then because even paper documents had a certain kind of metadata, name of a custodian, location, drawer, floor, file, whatever it may be. We needed other load files for such things as metadata. And then we needed a load file that said what file went with what image and so forth. And it went on the portable media of the day. And it was sent to lawyers for review in the state-of-the-art review platforms of the era. And it was good. It was good in the 1980s. But in time, we evolved in the practice of law. We moved towards being juris doctor electronicus. And so today, I'd like you to consider these 6 personalities. I mean, these people aren't like us. We're talking about the King of England, the Pontiff, the Oracle of Omaha, Warren Buffett, George Clooney, Beyonce, or Jeff Bezos's ex-wife and noted philanthropist, Mackenzie Scott. These people are billionaires, they're powerful, they're influential, we watch their every move. And so you'd think that if they went to create a document or a spreadsheet or a presentation, that they would be using some gilt-edged, much better piece of technology than we use. But the truth is, that's not the way the world works today. Today, if the king or Beyonce wanted to create a spreadsheet or a PowerPoint, they would go and use the very same operating systems and tools that we use as mere mortals. And they would work in the same sorts of common productivity formats that form the crux of electronic discovery today. So, what is an Excel spreadsheet? What's the nature of the evidence? Well, we know it's composed of formulas, and it's composed of formulas that lie beneath the values that we see. Spreadsheets allow us to make alterations in values and approaches, to do what-if calculations. They allow us functional layouts, and they encompass a world much broader than the measly confines of an 8.5 by 11 piece of printed paper. They go on for hundreds upon thousands and thousands of rows and columns very often. So when we think of a spreadsheet as a native user, we think of something more like this. And this is what a party would use. Notice how it uses structure and breadth and color to provide intelligibility. But if a spreadsheet is produced as a TIFF plus image, you get something more like this. Here are 4 pages of a spreadsheet. And what do you do when you see in an 8.5 by 11 TIFF format something like this? So without the structure and the utility of a native form, it's just useless. It's a joke. But what about a PowerPoint? PowerPoints have rich media and color and animation and speaker notes, perhaps, and layered imagery and text. Remember this slide that I showed you just a few moments ago? Remember this one where I talked about all of this, and you saw these animations and things coming in and going out and moving up and down and so forth? Well, that's all one slide. This is all one slide. And here's that one slide produced as a TIFF image. It's junk. It's useless. Try to do OCR on this and you'll see what you get. Total waste of time. What's a native email? A lot of people say, Craig, well, surely you're not going to insist on getting native for the email. At least with an email, you'd have to agree that a printout style like a TIFF is going to work. And I say, no, actually not. Because emails are generally conversations. And to get that conversational production, I need threading data, the things that are in the email that allow me to maintain that conversational structure. And I need to order emails according to a proper, trustworthy timeline. And so I need those UTC offset values that allow me to know that even if an email comes from another time zone or using another approach to daylight savings time, that I can order them perfectly. And I don't get that when I get production in TIFF Plus. Or take something as simple as a cell phone photo. It's replete with embedded information that's so important to the authenticity, the trustworthiness of that photographic evidence. Because inside a photo taken from a cell phone is generally the so-called EXIF data, including such things as latitude and longitude and altitude, that allows me to know that, say, an accident scene photograph is relevant contemporaneously with the events it purports to depict or the condition of the roadway, to give just one example. Well, what about a Word document? Surely, Craig, you can't be advocating that Word documents, things that we expect to be printed in their final usage, will be unacceptable in a print-like format. And I'm afraid there too, we're left behind when we resort to TIFF imagery, because there's more than appears on the TIFF image, a lot more, such things as comments and tracked changes, and metadata and dates. And comments and track changes, which we may dismiss as mere metadata, is actually content contributed by the authors and collaborators on the documents. And it shouldn't be stripped away as if it was never there without any legal justification, such as privilege, in order to allow it to be erased without any form of review by either side in a case. So when evidence is imaged to TIFF or printed to paper, that content and more is lost. By way of example, here's a depiction I've done of a simple file of the Gettysburg Address. And there were different versions of the Gettysburg Address that Abraham Lincoln wrote at different times. And so I've cast them together so we can see that, and Mary Todd Lincoln's comments and so forth. And so just know that basically this is a document of the Gettysburg Address. And here we would be seeing what Lincoln, what the witness saw as the author of the document. This is the evidence. Now, produced as a final document with all of this suppressed or taken away, this is what a lawyer would see. Only the final version and none of the process that is actually part and parcel of the original evidence. And this is what a searching lawyer would experience, because this is what search tools would see. Sub silentio, beneath the layer of what you see on the screen, OCR distorts the famous 7 years ago language to something essentially unsearchable. But even if we do it better, and when it's done well, we extract the text directly from the electronic document for the load file instead of OCR, even then, the process of embedment of all of those formatting codes and comments disrupts the ability to have a reliable search of the document while it's in a review platform. So by native production, we have the ability to see the evidence as the witness saw it, as the witness can authenticate it, as the witness won't be able to object, no, that's not familiar to me. But we also experience diminished utility when we talk about using TIFF+. And this is a little trickier to get across. It's more subtle, but I think you'll find that when you think about it, it's very important, and you don't lose that same level of utility when you seek native production. So here's a document I used in some litigation out of Chicago a couple of years back. And in this particular case, I took the proposed protocol for production and I made some margin notes as comments. And you can see when you're reviewing the document, you're seeing what I said, and notice how it is juxtaposed immediately adjacent to the proposed changes and deletions. This is essential for intelligibility. What was going on and where do the comments apply? But with TIFF production, you are limited to electronic search of the extracted text load file. Remember, TIFF plus means TIFF plus a series of files that you have to bring together as a kind of kit that you assemble to make search seem to correspond to the image of the page. And if you were to dig into the accompanying text file used for search, you might be surprised to note that all of those comments have to go somewhere in that text file. And very often they are simply agglomerated and dumped at the very bottom of the text file. So if they are included at all, which is to say, if they are not stripped away, as generally occurs, as if they didn't exist in the document, those times when they are collected, they are dumped at the end of the extracted text file. And so any search for what they contain not only will bring you only to, say, the last page of the document, but you won't have any pointer, any way to link what's in the comment to the place that it appears in the evidence document. And that is simply maddening to encounter. When somebody says no or yes or don't, and you don't know what they're referring to, that's just kind of crazy. An alternative to that you may run into is the commentaries are sort of embedded into the document text. They're kind of merged in a somewhat random way. And while that means that the comment is juxtaposed next to the accompanying text, it disrupts the searchability of the text so that you will be able to search for certain phrases. Certain phrases will fail if the comment happens to fall between the components of the phrase. Now, you have opponents that may try to offer you a solution. Well, don't fall for the fix that fools you. So you may have an opponent that says, don't worry, we'll deal with that. We'll go ahead and TIFF it a second time, and we'll give you another TIFF image, and this time we'll put those images on the page. And so now you'll be able to see the margin notes and comments right there on the image. The problem with that goes back to another means by which it disrupts search. And I discovered this problem a few years back in cases involving damage to roofs from hurricanes and hail in South Texas. And in that case, one of the things that was a search term was the term roof vent or roof vents. Well, when you do OCR on these strange revealed comment documents, the OCR isn't very bright. And so what happens is it looks at the document and it looks at the comment and the dot leader that points out to it, and it says, I got to figure out how to deal with this. And it sort of merges the DNA. And so roof vents becomes instead R.O.O.O, etc. It merges the dot leader and it merges the text, and meaning that no search you do for roof vents is going to work, because who has the presence of mind? It always reminds me of an old movie from back in the mid-'80s with Jeff Goldblum and Gina Davis called The Fly. And in this one, Goldblum is a brilliant scientist with a teleporter, and he decides to test it on himself, as all these mad scientists tend to do in the movies, and he jumps in the transporter, unaware that a fly has entered with him. The computer, sort of chat GPT-like, decides instead to merge the DNA of the two organisms, and he becomes Brundlefly, the monster. And that's what I think happens sometimes in e-discovery, is these efforts to solve things without simply going back and giving people the native forms of evidence give us these monstrous outcomes. And just for example, I need to have a final view. If you just give me these commented views, I'm not going to have that final view I can use. That may be the only one I'm allowed to introduce into evidence. And so what has emerged over the last 40 years in dealing with the move from principally paper evidence to almost exclusively electronic evidence is that now we continue to apply 20th century methodology to 21st century evidence. Remember, I showed you that 20th century methodology a few slides ago, but now here's what happens in a TIFF plus process. We have the native evidence, the real evidence, and it's printed to TIFF images in black and white. Because those aren't searchable, we either extract text or we perform OCR, and that has to go into load files. And then we have a load file with the metadata and Bates numbers and other information. And then we need a load file to tell us how to put Humpty Dumpty back together again and make it all work in a piece of review software. And so we end up getting this erector set, this Lego kit that we have to assemble. And the problem is not only is assembly required, but what we don't fully appreciate is just how many parts are missing. It's the IKEA box with the parts missing and not enough screws. And oh, by the way, we didn't get the hex wrench either. So it's awful. But if none of that impresses you, if the lack of utility doesn't impress you, let's talk about money. Okay, cost is the clincher. And this, I think, is going to come as a surprise to many listeners, and I think a very important point. That native docx file, that Gettysburg Address example, that was 29 kilobytes. If I turned it into a PDF with searchable embedded text, somewhat better, that's 199 kilobytes. I mean, what have I gone up? Something on the order of 6, 7 times larger? Okay, well, as you say, come on, Craig, 199 kilobytes, what's the big deal? Storage is cheap. If I turned it into a TIFF with accompanying load files, 453 kilobytes. It doesn't work as well. It's not as searchable. It doesn't carry rich information like animation and color and so forth. And it's 15 times larger than the native. We live in a day where in order to review information today, we have to use tools. And typically we are using online review platforms. And you know how you pay for those services? Almost exclusively by the gigabyte. So if someone is giving you something that not only is dumbed down and less functional, but it's 15 times larger than what they get to work with, how would you feel in any other sphere if you were being charged 15 times too much to get less? Now, I know some of you are skeptical and you're saying, come on, I'm no fool. If I was being charged that kind of premium, if somebody was messing around with me by giving me something so much more expensive than what I'm entitled to request and receive, surely I would know about that. And so I often say to lawyers, look, don't take my word for it, prove it to yourself. And that hasn't panned out because most lawyers don't have that kind of time. But the beauty of being a law professor is I can tell my students to do something and they'll do it. And I teach a course actually at 3 different schools at the University of Texas, at the School of Law, and it's also taught at the Information and Computer Science grad schools, and it's called Digital Evidence and Discovery. And I use an electronic evidence workbook with many, many exercises the students do. In exercise 21 in this last semester, I required the students to use commercial tools to process a set of data. They process about 55,000 emails from the John Podesta email collection. And then I asked them to export standard production sets, do one in natives with load files, do one as a TIFF plus with load files, identical stuff, but the only difference being the form of production, and then compare the size of those 2 different sets. And when they do, I ask them to tell me the difference. And let me tell you, that's when they wake up. And that's when I hope you as listeners will wake up to this, because we've got to stop this insanity. These TIFF productions, for all their other problems, they're just too fat, and we're paying for it. Well, I have put some things out there that I hope will help you. They're free. They're not selling you anything. And so these are some guides you can pick up at my website, craigball.com. They're on the left side of the website when you go to the page, craigball.com. One of them that I wrote just this year is called the Annotated ESI Protocol, and it goes through the kinds of provisions you'll want to work with your opponents to arrive upon, including how to ask for native forms, as well as, for those of you determined to do it the old way, how to at least improve upon a TIFF plus production. And I talk more about forms of production, and there's one dedicated to modifying your request for production so that you can get better and more economical forms. And I also talk at my blog, which is ballinyourcourt.com, about a variety of ways to improve your approaches to e-discovery, including one, this is one from January of 2020, where I go deeper into how TIFF makes it harder for you to get accurate searches. So as I repose the question, do forms of production really matter to you? I hope your answer is that they do, that they matter from a standpoint of functionality, they matter in terms of the substantive content of the evidence, and they matter to the bottom line. Because some items just don't work in the wrong form, spreadsheets being the classic example. Anybody who tries to give you spreadsheets in anybody that native form thinks you're a fool. And if you accept it, you'll make them right. You know, many lose content in the wrong form, like all the comments and track changes and other information and meta information that exists in native Word documents. And every one of them are going to cost you more to ingest and access month to month, year to year, when you get them in non-native forms. And so what's the pushback? people say, okay, Craig, well, what about redaction? I have to redact things. How am I going to redact in native? Well, there are ways to redact in certain native forms, but I'm not going to try to win that argument. In my experience, redaction is typically a relatively small percentage of the volume overall of information that is produced. And so since you're going to mess with the production anyway by blacking it out or doing what you're going to do, and since it's only a relatively small percentage, I say don't let the redaction tail wag the production dog. What I mean by that is continue to produce redacted items in whatever diminished form, like TIFF, you feel obliged to use for your comfort. But don't, by virtue of your segregating and producing them in a diminished form, don't require me to accept all the things I'm entitled to get without redaction in that diminished form. Don't let the tail of redaction wag the production in a more utile, complete, and functional format. And then they say, in pushback, well, what about Bates numbers? I got to have Bates numbers. There are challenges to Bates numbering until you think about it. And a great philosopher once said about Bates numbering, you can't always get what you want, but if you try real hard, you can get what you need. And what we need with Bates numbering is the ability to preserve all of the advantages I've talked about in terms of native file-based production, but being able to have that explicit page-related Bates number for reference in a proceeding. So it's a false narrative to suggest you can't Bates number electronically stored information in discovery. You absolutely can, because that evidence exists properly unitized as a file. You, the producing party, get to Bates number the files. You assign a Bates number to the file. You can put that Bates number in the name of the file. We've done that for a long time. But what happens is users, recipients, anyone using the very small subset of what we get in discovery, we get lots of things in discovery. Good lawyers only use a handful of items in actual proceedings, depositions, in-court hearings, making a record at trial. And so we wait to add Bates numbers at a page-based format when we change the form to a page-based format, when we reduce it to, say, a paper document we're going to hand across a deposition table. And that's when we physically emboss the electronic Bates number from the file, so we can always relate back to the originating evidence, and a pagination on the file, which every printer and electronically and physical can do. And then we have the ability to make that familiar record of turn with me, Madam Witness, to page 22 on Exhibit 3. So to put it in the context of e-discovery and the EDRM, we add Bates numbers at this phase of the EDRM while it's still being controlled by the producing party, and anyone subsequently changing the form for presentation adds the Bates numbers at this stage. So we have the best of both worlds. We have the ability to identify the item without doubt when we are using it as native forms, no loss of relation back there. And we have that granular means of identification by embossed Bates numbers on a page image at those times when we convert it to a printout or to another electronic format. So we've been doing this for a long time. All these years that people have been creating TIFFed page images, we've been naming them according to their Bates numbers. So this is nothing new. It's not rocket science. We've been doing it forever. To understand this is more than just something that will give you access to higher quality evidence, more faithful evidence, evidence that's easier to authenticate, evidence that gives you the full picture and, bottom line, costs you a whole lot less money. It may keep you from looking like a fool before the court. I'll give you an example. Here's a case from just a couple of months ago. This one's out of Utah, called Boulder Falcon versus Brown. And this is what most of the people in my line of work would call a pretty simple production. It was only 6,800 pages. In the world of modern electronic evidence, that's kind of head of the pin kind of size of production. And the requesting party received a standard TIFF images plus load files production. So unfortunately, the defense counsel, who was the one who received the production, in this case, the plaintiff was the one making the production. Defense counsel didn't understand what a TIFF plus production was. He saw a bunch of images and was frustrated because when he looked at the images, they didn't seem to correspond to the same exact order as he expected them to correspond in an email. And of course, if you've done electronic discovery before, you know that by virtue of deduplication and other mechanisms, you have family relationships between attachments, and the transmitting message is preserved, but it's preserved by so-called logical unitization. It's preserved by the load files. And when you put it into a review platform, as unfortunately defense counsel didn't understand is something you've got to be able to do in modern times, he got very angry. It seemed like to him that it was a data dump, that they'd thrown them up in the air and put it all together just to frustrate him. And of course, he didn't pick up the phone or send an email or a text to his opponent and say, what gives? Why is it this way? Why is it out of order? He just got angry, as we tend to do sometimes. It could be anyone. And he noticed the apex deposition of his opponent's CEO, and then spent hours browbeating the CEO about each document. And that was bad. And so plaintiff's counsel stopped the deposition, asserted it was taken in bad faith. And naturally, the defendant responded, not with what gives. He wasn't listening anymore. When they tried to explain a TIFF plus production, he wasn't listening because he was so angry. He just went for sanctions for stopping the deposition. And sanctions were issued, but they were issued against the counsel who browbeat the CEO by virtue of the fact that he didn't understand modern e-discovery. He acted out of anger. He didn't bother to communicate with his opponent about forms of production. So as I try to wind this down now, I want to share a few key takeaways with all of you before we take a few messages, a few questions. And again, it's so important, never ever lose the opportunity to specify forms. In the articles that I've directed you to, and certainly other fine publications out there, there are very good advice, utile advice, things you can build into your standard forms, things that you can think about and tailor to the proper case and practice, as we should always do. So always specify forms. And now that you have, I hope, a little deeper understanding of the way these things come, these sort of kits with load files, you always want to be speccing what comes in the load file as well. Don't leave it to chance that you're going to get the fields of meta information that you need to make good use of electronically stored information. Make sure you spec what it is you're asking for and the form in which you want it. It's your right to make that specification. Sure, the other side has a right to object to it as well, and they have a legal obligation before they produce in a way different than you specify to tell you what they're going to do, so you're afforded the opportunity to resist their deviation from your specification. That's one of the rules that gets broken quite often. Know that's your right, and know that if you don't get that timely objection and opportunity, that you can force them to do it again at their cost. And be sure to tailor your form specification to your needs. This is something you need to take a moment to think about. Think about, what do you need to do with the evidence? If it's a spreadsheet and you need to do what-if calculations, only a spreadsheet format's going to work for you. If you need to think about, what do you need to know about the evidence? If there's a question of fabrication or trustworthiness or temporal relevance, you need it in a form in which you can dig into the indicia of authenticity associated with that electronic evidence. So please don't be that lawyer who, in that intense desire to get something, you unwisely accept anything. And while I'm wrapping it up, two considerations for forms. Remember that according to the rules, a responding party cannot convert electronically stored information to a form that's significantly more difficult or burdensome for a requesting party to use efficiently. They're not obliged to always give you the exact same form, but they are legally obligated to not give you something that is significantly degraded, that is not reasonably usable. And I hope that I've equipped you with some of the arguments to demonstrate why the forms they try to foist off on you are not only not complete and utile and reasonably usable, but worse, they're visiting significant additional and unnecessary costs upon you just to make your life more difficult often. Also know that a responding party cannot act to remove or significantly degrade the searchability of the ESI that they give to you. Your opponents are probably blithely unaware of what they're doing when they give you these text extraction load files and the problems that they will create for you, because they're often not giving you things you're asking for because they've dumbed it down in some of their own systems. And so you need to be astute and know that if there are things out there that you're missing because of the way they process the data into these extracted text files, you need to push back and remedy that. So I mentioned some things out there. The same items here, the annotated ESI protocol, the lawyer's guide to forms of production, which I've had out for a few years, and another one I've had out for a few years, modern requests for forms that function. And again, I encourage you, it's free and it's not selling you anything, not selling you me. My blog, ballinyourcourt.com or craigball.net. craigball.com is the website with the articles on it. craigball.net or ballinyourcourt.com is the blog. And I have more about how you can improve your requests to ensure that you're going to get the native forms that you need when you need them. Okay, thanks for listening. And I'm happy to answer any questions that you might have. I'll stop this share and see where we are.
Thank you, Craig. We can move on to the Q&A. It looks like we've already got a few questions, so we can go ahead and jump right in, Craig. Our first question is, how do I tailor my e-discovery requests to address the challenges of different digital platforms like social media, messaging apps, cloud storage, etc.?
First of all, you need to decide what it is you're going to be using to review these things, because specifying a form where you haven't the tools, or for that matter, the ability to use those tools in order to complete those reviews has to play a role in what you ask for. So I have good tools, and good tools are available affordably for all of us today. You know, what constitutes affordably obviously varies from pocket to pocket. But whereas a few years back, and I'm not trying to mention any particular vendors, but there are a lot of them out there today that you can afford to use their tools to ingest and process and host data for fairly nominal sums of money. I mean, measured in hundreds, not thousands of dollars. And so I like to get information as close to the form in which I see it in the native applications as I can. So if I'm working with Facebook content, for example, Facebook provides a so-called Facebook takeout, the ability for the account holder to bring it out in an HTML, a web-based format that does a pretty good job integrating the imagery and the contents of your wall and the likes and so forth. And so I might do that. One thing I would stay away from is screenshots. Screenshots are notorious for being bad evidence. They're not searchable inherently, and it takes an enormous amount of effort in order to be able to capture all of the details, to essentially open up all of those layers of data in social networking and may expose all the comments and the likes and so forth and the commenters. To try to do that in a screenshot is mind-numbing time consuming, and everyone makes mistakes at it. Plus, for those who are not playing fair, it allows them an easy way to sort of slide in false content or take out things they don't want you to see. So stay away from screenshots, go for the native. When we're talking about other forms, it's very specific to the form. If it's tweets, it's one thing, and there's a takeout. Google content has a takeout. I don't think it's the requesting party's responsibility to necessarily give the play-by-play to an opponent as to how to preserve and retrieve. I often do, because I've spent so many years dealing with people who had not a clue. I wanted to shut the door on spoliation by giving them that play-by-play. But I know how to do that, and I don't expect that most trial lawyers will. So I would say, give them tell them in your meet and confer the platforms you plan to use. Tell them the aspects, the metadata, what pieces, what aspects of the data you need to have complete and functional and utile, and let them figure it out, and ask them to perhaps give you a sample of the data before they make a much larger production, so you can say, yes, that's okay. And that saves both sides a lot of heartache and money. Most good litigants are willing on atypical forms of ESI to give you a sample of the way they're going to produce it, so that they can get you to mount your objections before they spend a lot of money giving you something that you're going to be within your rights to reject.
Thank you.
Sure.
Our second question is, as data privacy regulations increase, how can I balance obtaining relevant ESI and maintaining privacy and security during the e-discovery process?
Wow, that's a topic for not just another hour of CLE, but a symposium. And it has been the subject of a number of symposiums. There are no quick answers. It depends. Would I be any kind of lawyer if I didn't throw in that answer at some point along the way? So what it depends upon is, where are you? Are you operating in Europe under the GDPR? Are you dealing with PII, personally identifiable information, like social security numbers and other identifiers, bank account numbers, credit card numbers? Because there are all sorts of ways to skin that cat. There are mechanisms of search that can be used to redact PII and still be able to do e-discovery in fairly familiar ways. There are enormous complexities in trying to do cross-border e-discovery. We begin talking about what even constitutes a word we think we understand in the States, like processing. But when you use a term like processing overseas, it means something much more difficult with which to comply. I mean, just basically copying a document in Europe is deemed processing and brings you under the umbrella of the privacy regulations of the EU. And so I don't have a quick answer to how do I solve that. The answer is that if you're operating cross-border, if you're operating, you've got to have an understanding of the operative statutes, and you may have to do some very significant work in the host country, because most host countries around the world do not regard the United States as a safe place in which to allow the expatriation of the data of their citizens. And so that's, like I say, that's a much bigger question that I wouldn't even try to attack here and now. If you're dealing, however, on a much more simpler level of privacy, how do I divide private content on a cell phone, say, from corporate content? Here again, there are ways to solve those problems. They're very practical, they're very affordable, but that process starts with understanding what you're dealing with. What are these things? What forms do they take? I mean, ultimately, it's not ones and zeros even. It's ultimately magnetic remnants and electrical charges and so forth. When you get down to the media, it's all the same. It's just data, as IT people are fond of saying. It's all soluble, but unless you're going to have the budget to hire an expert like me, which I think isn't the solution for the rank and file from the 80% of cases, then in order to be able to do it right and do it economically means that we've got to study this stuff. We can't just be content anymore with saying, I'm a really good lawyer, I studied the law years ago, and that should be enough. The world has changed, and we've got to change with it. And that means making it a part of your professional development to begin studying these things. I mean, I've given you some things to read. I'm not suggesting that by itself is adequate, but where else are you going to go? The bars have dropped the ball. An hour or two of CLE once a year is not going to get you there. The only thing that's going to get you there right now is your determination that you need to learn it, because it's going to serve your clients. It's going to save you money. And if you're a contingent fee lawyer, that bottom line certainly matters. And saving our clients money, letting our clients know that we're not wasting their money, we're not subjecting them to wasted our professional time, or doing stupid stuff like the lawyer in the case that I just shared with you. That's survival in a highly competitive field.
Thank you, Craig. That really nicely leads into the last question that we have time for. You already touched on a few points, but the question is, why is it important to stay current with the evolving landscape of digital evidence and e-discovery's impact?
If you've reached an age of retirement and you have oodles and boodles of money in the bank, it's not. If you want to go to dental school, I suppose it's not. But if you want to be a lawyer who does a good job, a job you can be proud of for your clients in a modern litigation environment where, let's face it, all the evidence is born electronically now, and the ability to know what's there, the ability to weave it into your case, and not only to be able to identify it, preserve it, collect it, search it responsibly, review it responsibly, redact it responsibly. You've still got to be able to use it in court. I know for a lot of us, we've forgotten what going to court even looks like anymore, but that's where the rubber still meets the road. And we're going to be facing a host of deep fakes and other information that are going to require us now more than ever to be understanding, appreciative of what electronically stored evidence is, what's inside of it, what is its meta information, what does it signify, and how do we use it to prove and challenge electronic evidence before tribunals. That's modern law practice today, folks. And either you're going to be the butt of the joke who did the Chat GPT brief, and I don't want to be a butt of a joke. I don't want to be somebody's punchline, and neither do you. And that's the best reason I can give you, because making money's nice, but I think our pride, our desire to be competent, admired contributors to our justice system is what drives us more than just the dollar.
Absolutely. Thank you so much, Craig. And thank you all for your questions. We are almost out of time for today, so I'm going to go ahead and hand things back over to Marina to wrap things up.
Thanks, Nina, and thanks, Craig. That was a fantastic presentation. I hope all of you enjoyed it and you learned something that you can apply in your own practices. If you're looking for new clients, if you're trying to grow your practice so you can apply some of these strategies or some other things you've been looking at, please remember that Justia has marketing solutions that will be able to help you. We have Justia Elevate websites, which are great, affordable options to help you increase your visibility online. We also offer the Justia Lawyer Directory, which you are all already listed in, and premium placements to help you increase your presence in that Justia Lawyer Directory. And of course, we have PPC advertising solutions available with our Justia Amplify services. Now, have a great weekend, a great rest of your Friday, and we will see you next time.
We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.